Good morning, Miss Alexander. Ma'am, you're charged with the offense of driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause.
Right out of the gate, this courtroom feels different. A high-blow DWI case means the stakes are already elevated, but what really matters here is how the judge sets the tone. Watch closely. This isn't just routine processing, this is about accountability.
You are Janae Alexander?
Janaya.
Janaya? So you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
On March 22nd, 2025, an officer responded to a minor traffic incident. Upon arrival, the officer met with the wheel witness officer who stated that he was conducting a safety control of a disabled 18-wheeler on the shoulder with his emergency lights activated. The officer stated that he was on the shoulder when he was struck on the driver's side by the defendant's vehicle. After the crash, the officer observed the vehicle to continue to travel southbound. A traffic stop was initiated. The officer made contact with the defendant, the driver, and sole occupant of the vehicle, and immediately detected the strong odor of alcohol upon her breath and slurred speech. The defendant exited the vehicle, and the officer observed unsteady balance. The defendant admitted to consuming alcoholic beverages prior to driving.
That admission right there? Huge. In DWI cases, voluntary statements can seriously strengthen probable cause. Combine that with physical signs like slurred speech and balance issues, and the case starts stacking up fast. Do you think she realized how much that one statement could cost her?
The affiant officer made contact with the defendant and observed the same signs of intoxication. The defendant stated that she was on her way home from a bar and consumed 1 mixed drink at 9 p.m. The defendant stated she was unaware of when she struck the patrol vehicle. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues observed on the walk-in turn, 2 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were .202 and .201.
0.202. Let that sink in. That's more than twice the legal limit in most states. At that level, impairment isn't subtle, it's undeniable. And when juries hear numbers like that, it becomes much harder for the defense to argue doubt.
Any prior DWI?
No prior, Judge.
License?
Oh, yeah.
Okay. Ms. Alexander, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? Ma'am, look at me. If I find that you're using, it's not going to go well for you. I'm not asking much from you. If you do not have a valid Texas license and liability insurance in your name, car insurance, you're not allowed to drive. That is also a condition. Do you understand? How old are you, man? You're
23 years old and already facing consequences that could follow her for years. This is where the judge shifts from procedure to warning. It's not just about punishment. It's about preventing the next mistake. Do you think moments like this actually change behavior?
23.
Do you have the ability to hire a lawyer? Would you like to apply for a court appointment?
I need one.
Okay. So Deputy Miranda is going to give you an application for an appointed lawyer. I'm going to have you sign a receipt. Victoria will have you take a seat in the jury box while you fill it out. You will meet with pre-cooperative bond conditions, and then I'll have you talk to someone here shortly. Okay? Are you Victor Ortiz?
No, Judge.
No, this is Osman Rodriguez.
Yes.
Mr. Rodriguez, you're charged with driving while intoxicated. You're facing up to a year in jail and or $4,000. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 21st, 2025, an officer responded to a two-vehicle accident that occurred near the 5,000th block of Bingle Road. The complainant stated that she had made a right-hand turn northbound on Bingle Road and was already traveling northbound when she was struck on her driver's side by a white van. The complainant identified the defendant as the sole occupant and driver of the striking vehicle. The officer made contact with the defendant and observed red, glossy eyes, the strong odor of alcohol upon his breath, and sweat. The defendant stated he consumed 2 beers, one at work and one in his vehicle as he was driving home. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 2 out of 4 clues on the one leg stand. 3 out of 8 clues on the walk and turn. The defendant consented to provide a breath specimen. The results were .160.
Now here's where things get interesting. We're seeing a pattern. Multiple defendants, similar charges, and the same uncompromising tone from the judge. This isn't coincidence, it's a message. Zero tolerance. And every new case raises the stakes for everyone watching in that courtroom.
And .177.
Did they find alcohol in the car? Substantiate that allegation.
Doesn't state in the judge.
Does he have a license? And any prior DWIs?
He does not have a driver's license and no prior DWIs.
Mr. Rodriguez, I'm going to find that there's sufficient probable cause to go forward with the case. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. That is a condition of your bond. I will have you sign with me today a promise to me that you're going to make. This is an affidavit that I take absolutely serious. I don't care what's going on in your life. I don't care if you have a bunny that needs operating. If I find that you drive, it's not going to go well for you. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication, and you will be randomly tested. If I find that you're consuming, likewise, I will revoke your bond, put you in jail. No more PR bonds for you.
And there it is, the strongest warning yet. The judge isn't just talking about fines or jail time anymore, but life-altering consequences. Immigration, repeat offenses, community safety, it all comes together here. The real question is, will these warnings stick, or will we see these same faces again?
You have a lawyer. Because you have a lawyer, I will waive your appearance. Mr. Rodriguez, it is your responsibility to stay in touch with him. If Mr. Salinas tells me that he can't get a hold of you because you're playing games, you pick up a new case, you endanger my community, I will put you in jail. For now, I'm going to have you come up here and swear to us that you're not going to drive. I will get you to Victoria. We will have you sign a reset. And then after that, I will get you with pre-trial. And then after that, you're free to go. Come on.
Yes.
Mr. Sierra, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you soon.
On March 23rd, 2025, an officer observed a vehicle engaging in illegal street race at the 12,425th block of Wood Forest Boulevard in Harris County, Texas. Both the defendant's vehicle and another vehicle passed the officer at a high rate of speed while attempting to pass each other in a competitive manner in an attempt to outdistance each other. The officer observed the defendant drive 96 miles per hour in a 40-mile-per-hour zone. A traffic stop was initiated. The defendants began to pick up speed while swerving through multiple lanes and cutting off other drivers on the roadway in an attempt to outdistance each other. The defendant admitted to speeding but denied racing. The co-defendant is a juvenile.
You want his license? See if he has a license.
Yes, Judge. He does not have a driver's license on file, Your Honor.
Mr. Sierra, I'm going to find that there's sufficient probable cause to go forward with your case.
Así
You
que
do not have a Texas driver license. You are not allowed to drive.
no puedes manejar.
I'm going to have you sign with me today an affidavit, a promise that you're going to make to me that you're not going to drive. I don't care what's going on in your life. If I find that you drive, I will put you in jail. And if you're not in this country with permission and you go to jail, it's very possible immigration puts a detainer on you and you will be in there until this case is over with. How old are you, sir?
¿Qué tantos años tienes, señor?
20.
20.
Did you want to apply for a court-appointed
aplicar?
lawyer?
Sí.
Yes.
Look at me.
Dígame.
Heed this warning. You get no more. If I find that you're a danger to my public in any way,
¿Qué manera?
I will put you in jail in a moment's notice. Do you understand?
Lo entiendo.
Think before you act. You hang with the wrong people, it's not going to go well for you. Come on.